Hello and welcome to the Minimum Competence episode for Thursday, July 11th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have a SCOTUS ruling impacting Illinois corruption cases, Tesla's extended time to defend an insurance class action, Harvard's new general counsel amid scrutiny, and Giuliani's possible bankruptcy dismissal. Let's remember, the best music is essentially there to provide you something to face the world with and read today's legal news. On this day in legal history, July 11th, 1921, William Howard Taft was sworn in as Chief Justice of the United States Supreme Court, making history as the only person to have held both the presidency and the Chief Justiceship. Taft had previously served as the 27th President of the United States from 1909 to 1913. His appointment to the Supreme Court was a lifelong dream come true, as he had always preferred judicial work over executive duties. During his tenure as Chief Justice, Taft made significant contributions to the federal judiciary. He advocated for judicial reforms and was instrumental in the creation of the Judicial Conference of the United States, which helped improve the administration of the courts. His leadership was marked by efforts to enhance the efficiency and integrity of the judicial system. Taft's unique perspective as a former president provided him with a comprehensive understanding of the interplay between the branches of government. This experience enriched his contributions to the court's decisions and its operations. His tenure as Chief Justice lasted until his retirement in 1930, leaving a lasting impact on the American legal system. A recent U.S. Supreme Court decision has impacted two significant Illinois public corruption cases involving former State House Speaker Mike Madigan. The ruling in Snyder v. United States clarified that federal law criminalizes bribery when officials accept bribes before performing official acts, but not when they accept gratuities after the fact. That's awesome. Following this decision, defense lawyers in the cases involving Madigan and his associates are seeking acquittals or new trials. Judge John Robert Blakey of the Northern District of Illinois requested updates from the lawyers involved. Meanwhile, attorneys in U.S. v. McLean indicated they would file motions to acquit or seek new trials for four defendants convicted of conspiring to solicit favors from Madigan. Michael McLean's lawyer argued the Supreme Court's ruling showed the jury was misinformed on the law, potentially invalidating the conviction. Madigan's legal team plans to file motions related to the Snyder decision while prosecutors maintain their original allegations. Even if some convictions are vacated, the government argues that other charges, such as falsifying records under the Foreign Corrupt Practices Act, are likely to stand. Former prosecutor Rachel Cannon noted for Bloomberg Law that these additional charges might withstand the impact of the Snyder ruling. The Snyder decision might also influence other prosecutions connected to the Madigan scandal. Besides McLean, Jay Doherty, John Hooker, and Ann Pramaggiore were also convicted and await sentencing, which has been postponed pending the Supreme Court's decision. These cases underscore the significant legal repercussions following the High Court's interpretation of bribery statutes. A California judge has granted Tesla more time to prepare its defense against a proposed class action alleging it overcharged customers for insurance. The case, overseen by Judge Michael Markman of Alameda Superior Court, now has a hearing scheduled for October of 2025 to determine whether it will proceed as a class action. The lawsuit, filed on behalf of drivers in 11 states, accuses Tesla of inflating insurance premiums based on false crash warnings instead of actual driving behavior, violating California's unfair competition law and breaching contracts with drivers. Tesla's attorney, Min Kang, cited delays in gathering defense information due to the involvement of multiple states and the recent departure of a key Tesla employee. This personnel change has complicated the process, with Tesla in the midst of hiring a replacement. Tesla, which denies any wrongdoing, previously attempted to dismiss some claims but was unsuccessful. The company's insurance program bases premiums on a, quote, safety score, factoring in vehicle data such as hard braking and forward collision warning alerts. Plaintiffs argue these scores are unfairly increased by false warnings, raising their premiums. This lawsuit has drawn attention from state regulators and plaintiffs' lawyers, highlighting broader concerns about Tesla's insurance practices. Harvard University has appointed Jennifer O'Connor as its new general counsel effective July 29th. O'Connor previously held senior roles at Northrop Grumman and the U.S. Department of Defense. This move comes as Harvard faces scrutiny over its policies on anti-Semitism and calls from some students to sever financial ties with military contractors. O'Connor brings extensive experience from large, complex organizations and has served as general counsel for the Department of Defense and held roles in the White House counsel's office. She is an alumna of Harvard College and earned her law degree from Georgetown. Interim President Alan Garber praised her experience, emphasizing her readiness to manage Harvard's legal strategy amid congressional probes and lawsuits related to campus anti-Semitism and the aftermath of Hamas's attack on Israel. O'Connor will also address issues related to Harvard's admissions policies after a recent Supreme Court defeat. Neil Eggleston, who worked with O'Connor during the Obama administration, speaking to Bloomberg Law, highlighted her familiarity with Washington's political landscape, which will aid Harvard in navigating upcoming challenges. O'Connor succeeds Eileen Finnan, who had served as interim general counsel since March 1st, following the retirement of Diane Lopez. This appointment aims to stabilize Harvard's legal department and address ongoing campus controversies. Rudolph Giuliani's personal bankruptcy case is likely to be dismissed by a federal bankruptcy judge by the end of the week after nearly 7 months of inactivity. Judge Sean Lane of the U.S. Bankruptcy Court for the Southern District of New York indicated during a hearing that he is inclined to dismiss the case entirely, with a final ruling expected on Friday. This dismissal would leave Giuliani without court protection from creditors to whom he owes over $150 million. Giuliani's lawyers have consented to the proposed dismissal. The bankruptcy case has been fraught with disputes over missed deadlines and transparency issues regarding Giuliani's financial affairs. Giuliani filed for bankruptcy in December, reporting a $10.6 million in assets after a $148 million defamation judgment for false accusations against Georgia poll workers for the 2020 election. Wandrea Arche Shea Moss, one of the poll workers, sits on an official creditors committee that has requested a trustee's appointment. If dismissed, creditors could return to civil court to recover debts, and Giuliani would face continued lawsuits that were paused by his Chapter 11 filing. Attorney Rachel Strickland, representing the Georgia plaintiffs, criticized Giuliani's lack of cooperation and suggested he might commit bankruptcy crimes. This prompted a heated exchange during the hearing, with Giuliani interrupting to refute Strickland's claims. Creditors Committee opposes the dismissal, arguing that resolving the case within bankruptcy would benefit more creditors than civil court proceedings. Despite these arguments, the dismissal seems imminent, leaving significant creditors, particularly the Georgia poll workers, to seek recovery through other means. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice, because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, blind faith in your leaders or in anything will get you killed.